Hello, I'm Barrister Daniel Barnett. What is a security for tax notice? When you get one from Her Majesty's Revenue and Customs, do you have to pay it? Can you challenge it? What do you actually have to do? Well, here to answer that question is Camilla Rents, a criminal defence solicitor from OB Law.
Good morning. Notice for security in respect of tax at risk is a request by HMRC for payment of tax that has either become due or is likely to fall due as a company continues to trade. Now, in terms of when HMRC might issue such a notice, it's usually where a taxable person, so a company or a person registered for tax, in either their current business or a previous business, has failed to comply with their tax obligations, or if HMRC have some other reason to believe that they might not pay tax, a notice may be issued. A common scenario that this relates to is what's known as a Phoenix company. This is a situation where a company has been liquidated or sold out of administration and where tax has gone unpaid. HMRC may suspect that the formation of a new company is a mechanism for avoiding the payment of tax. And so in this scenario, a notice for security may be forthcoming from HMRC. And the notice for security is essentially a request for a deposit. It's where HMRC believes that tax is going to go unpaid and they require a payment for that tax up front. Once the notice is issued, payment as far as the law is concerned is required immediately. What is immediately? Well, HMRC's guidance states that they will allow a reasonable time for payment to be made. What is reasonable will depend on the individual circumstances. So the amount that's required under the security, the amount of any unpaid VAT at the time, whether the business is willing to enter into a payment plan in respect of VAT. Once the security has been paid, HMRC will hold on to that for at least 1 or 2 years, depending on the frequency at which the company makes their VAT returns. And once HMRC have monitored the situation and decided that the risk has gone, that there's no longer a risk, they'll return the security. Or at least in theory, that's what will happen. In reality, the security is not always repaid. If there are other debts that are owed to HMRC, the security can be used in full or in part towards those arrears. And HMRC may then require a further security for that for future tax that will then potentially become unpaid. Now, the law in this area is extremely draconian because once a security for VAT has been issued, a company commits a criminal offence if it continues to trade in contravention of that request. So that essentially means if the security is not paid immediately or within a reasonable time, every time it supplies goods or services after it's failed to pay the required security, a criminal offence is potentially committed in respect of each of those taxable supplies.
If the tax is owed by a limited company, can the directors of the company be held personally liable, and can the directors be criminally responsible themselves, or is it just the limited company that's potentially liable?
Personally as well, company directors, managers, secretaries, other examples of those sorts of positions are equally liable as the company, and HMRC will usually bring proceedings against the company and the director.
What can someone do to challenge a security for tax notice if they receive one? Is it something that can be appealed?
Yes, the notice can be appealed. It needs to be appealed within 30 days of receipt. The requirement must be a proportionate response to the level of risk that HMRC perceives, and it should go no further than to achieve that objective. So it is possible to appeal, firstly, the requirement for VAT in the first place, and secondly, the amount that's been requested. In terms of other options, they're pretty slim. Either the security is paid, or the company can cease trading so as not to commit a criminal offence, but the downsides of that are pretty obvious.
Are appeals often successful, or is it a once in a blue moon type situation?
They are successful. They take place in the VAT tribunal. A company director can represent themselves or the company. Tax advisors often become involved in appeals against notices for security for VAT, or indeed solicitors. And yes, they are successfully appealed.
So if someone receives a security for tax notice, what's the first thing they should do?
Read it. I think it sounds obvious, but what often happens is we're busy, we're bogged down in our day-to-day work. We receive an alien piece of paper from HMRC that talks about things that we've never really heard about, we don't really understand, mentions tax and VAT, and we dismiss it as yet another demand from HMRC. The consequences of ignoring a notice for security for VAT are potentially dire. Not only could a director personally receive a criminal conviction, there are financial penalties of up to £20,000 in respect of each taxable supply, and that doesn't then wipe out the notice for security. So you're potentially in a situation where the notice still stands, you've got a huge sum of security that you need to pay, there's a massive financial penalty from the courts, and a company's in a situation where it can't even trade its way out of the debt that it's in, because if it continues to trade in contravention of the notice, it commits an offence every time. So people often feel as though they're stuck in between a rock and a hard place. So read the notice and engage with HMRC.
Thank you very much. If you enjoyed this video, please do consider subscribing and click the notification bell as well, so you get updates on any new explainer videos about English law that I post. I'm Barrister Daniel Barnett. Thank you also to Camilla Rents, a criminal defence solicitor from OB Law, for her contribution. Bye bye.